Why don't we talk about the questions that I've given out. I had Dan post them online as well for those people that are taking the class online with section 12. I think it's important to start to fine-tune a little bit some of the concepts and think about damages, and a lot of these questions do that. And these questions illustrate, at least I think some of our discussion on these questions will indicate why I don't tend to like multiple choice questions with respect to the final exams. And you won't see questions of this sort or any type of multiple choice on the exam. The exam will have an essay. It'll have a series of short answer questions as well that you'll have to then define the concept completely and then apply to a fact pattern. I expect you to know the law well. I expect you to be able to explain it well. And when I look at your essay, I hope it's both the essay and the short answers are well written and clearly show a mastery of the material, so that I can give you all the A's that you want to get. But I think a lot of the concepts here are something we're thinking about. I think the problem with a lot of these questions, and this is always the problem with multiple choice, is if they're not written extraordinarily carefully, there's a lot of room for debate and argument, and it's a good thing from a pedagogical standpoint. It's not such a good thing if your grade depends on it. But these questions, I think, you could look at for some time. We haven't really given it that much time. I would hope people online would take the 20 or 30 minutes to go over the questions first and then listen to the discussion, because I think it helps to sharpen your focus a little bit if you've taken some of them and really given them some thought. I think with any multiple choice question, a good way to address it is by process of elimination, striking the bad answers and trying to improve your odds of passing the question. It certainly is the way you should attack the bar exam. It's really the way in which you should attack most multiple choice questions, by improving your odds statistically of passing that every time you can eliminate a bad choice. So let's take a look at question 1. The question calls for which of the following statements is true? A judge will always order specific performance if the defendant deliberately committed a breach of contract. A judge will always order specific performance if the defendant deliberately committed a breach. You like that? No. I mean, anytime you have these modifiers like always and the like, you have to be careful about when they're saying a judge has to do or must do something as well. But just because there's a breach doesn't mean you even may recover under certain circumstances, much less get the extraordinary remedy of specific performance. B, although the usual remedy for breach of contract is now damages, the courts historically awarded specific performance in most cases. What do you think of that? You like that? Anyone have that? No one have that? You have that?
That's it.
Well, let's take a look at the others and see what do you think B looks better by the time we're done. C, the plaintiff usually has the option of receiving either damages or specific performance. Is it simply up to the plaintiff in his or her option as to what they'd get? And the answer is no. Right? Specific performance, generally we're looking at unique goods. Certainly with respect to real estate transactions and the like, it's more likely that that presents those type of unique material that the court will look at. But it's not simply a matter of plaintiff's choice. D, the courts often prefer to award specific performance because business people are most concerned with money. Often, well, that internally doesn't even make sense, right? I mean, so D we can throw out because the logic's wrong. You picked E because there's a million other choices out there other than the 4 outlined above, and you went with your odds, didn't you? Well, the maker of the test says that you are wrong because they say, and historically, the preferred route, certainly in many breach of contract cases, was to go with specific performance. The drafters of the question say the right answer is B, and I think it is probably the best of the 5 choices. And I know when you get questions like this and none of the above is there, and it's there on a lot of these, you tend to think you're going to play your odds and take, well, I've got the whole rest of the world and just these choices, so statistically that might help. I'd be more careful with that. I do think B is probably, and this is where your reservation came from, I would guess, is even that is pretty broad. So Fiona and I have a contract for $500. She's going to paint my house, and I could get it done for $600, but she now refuses to do it for $5. That's not going to be a specific performance. That's going to be I get another $100, assuming I haven't paid Fiona or anything. So even B is an overstatement, and I could see why you might have picked E. But maybe you can get 2 right for me. What do you like for 2? Expectation damages are forward-looking, which is true, right? So what do you like for an answer? A? A, in fact, is correct. At least as they say it, right? A, because they are intended to provide the plaintiff with the benefit that it expected to have after the contract was performed. You'll remember we looked at, in the Pier 4 case, we looked at expectancy and reliance damages. And so you do want to have a good understanding of that. And as we saw in that case, it really matters that those things are pled, because in that case, the difference was hundreds of millions of dollars, depending on whether we looked at expectancy or reliance damages. And in fact, as we're going to see from a couple other questions here as well, that is often the case. Reliance might well save us from the bad bargain that we're going to see in a little bit as well. B, here the answer is just badly worded. Only if the defendant actually expected to receive a profit. Well, that wouldn't be the way. It would be the plaintiff who's seeking now to recover. C, only if the plaintiff actually expected to receive a specific profit at the time of entering into the contract. I think the modifier specific there is probably likely too narrow. D, because they intended, again, to provide the defendant with the benefit that it expected to have after the contract was performed. It really is the expectancy of the plaintiff that becomes important with respect to expectation damages. That's why the plaintiff's seeking to recover. So I think that's not a bad question. The right answer is A. Questions? That's pretty straightforward. 3, and this is the first of our calculation of damages questions. Chamit contractually agreed to sell a widget to France. You read the question. You have it in front of you. Which of the following statements is most likely true? The widget was really only worth 7, expected to sell it for 10, now refused to accept delivery of it. How much are Chamit's damages? What do you like?
D.
I heard C and D. D says they get $3,000. C says they get 10. Those that say Chamit gets 10, doesn't she then have both $10,000 and the value of the goods still with her? Because that sounds like a windfall under those circumstances, right? She gets to be made whole. She doesn't get to be made a winner of megabucks. And so what has she actually lost?
Just 3.
She lost what the profit should be, right? The cost of the good, or take the cost away from what she would have received. I think 3,000 is the right calculation there. And her expectation damages would be 3. Her contract, breach of contract claim would be 10, but she still has the goods themselves, and she would be obligated to mitigate their damages to some extent and sell them and the like. I think the right calculation is likely D for 3. Questions?
So you're not supposed to take these a step forward and think that, well, if she then sold it to someone else for $10,000, she would be unjustly enriched because she wouldn't have any damages.
Well, but what if she turns around and sells it for 1? I mean, you've got to work with the facts you have. Right? Right now, we know she's got something that appears to be worth 7, and in essence, she's lost 3. You've got to work with the facts that you got, Karen.
I can't argue with it.
Okay. 4, cost of pure damage. And listen, by the way, she holds the 7 goods. She recovers her 3. If later on she ends up selling those goods for 15, she has recovered a windfall, but her damages at the time she filed suit against Franz were in fact $3,000. It really is in some ways a matter of timing. But you know, and we haven't talked about that much, but that's the way it is with a lot of cases and damages, right? Someone sues for personal injuries, and I expect that my arm will never recover 50% of its use. Well, you know, miracle of miracles, right after the lawsuit settles, they now don't have that 50% loss anymore. They've recovered full use of their arm. There's no rebate coming. And the other side of that is sometimes people get sicker after the case is resolved, or there are further damages, and well, that's just bad, too bad. At some point, the case goes forward. I read a very interesting one yesterday. It's tangentially related. I liked it. I should have brought it into you. The divorce case gets resolved. Big divorce case gets resolved. About $13 or $15 million distribution of assets. Wife takes hers in cash. He keeps the $6 million they had in the Madoff account. Honest to God, it was yesterday's paper. He keeps the $6 million he has in the Madoff account. A year later, he's got zero in the Madoff account. He goes in to try and reopen the divorce agreement, divorce settlement, and the judgment, and the court, his wife of course says no. Court ultimately says, no, you had it at the time, there was a, you're like, you know, there did seem to be a cruel irony to it, didn't there? So at the end of the day, they actually both husband and wife were lawyers, and in fact represented by counsel at the time, and in hindsight, he made a horrible deal, but the deal is the deal, and she gets to keep all the money, and he lost most of what he had pulled out of the marriage.
And what was his argument?
Well, his argument sort of is the changed circumstances, or it really isn't what we thought. A mutual mistake is what he was arguing. We both thought the Madoff account was worth $6 million, and well, the court says it was. I don't quite agree with that, because I don't quite agree with that.
That was mutual mistake?
No.
No. Court says he's out. This is no mutual mistake.
Oh. What
you got at the time was worth $6 million. You could have gone down to Madoff, taken out that $6 million, and you would have been all set. And that may be true, but it depends. There's a whole timing issue. There's other issues there, but that's what. Listen, New York, I'm sure looked at it, and the lawyers looked at it very carefully, and they said he's not. You can't go back now. The case is over. It's resolved. We're moving on. And so I thought it was an interesting twist on it, but as a general matter, that is the way it is. If things change after the judgment, after the resolution, and oftentimes, except for a lot of the child support issues and modifications like that, the deal's the deal. And the fact that didn't work out, or you've squandered your money, or whatever else, that's just the way it goes. Geneva, what were you had?
Never mind.
Huh?
Never mind.
You good? Okay. So the cost of cure, we're good on. Oh no, we didn't do that yet, right? No, cost of cure damages are intended to compensate the plaintiff for an intangible loss. Well, it can't be intangible. If the cost of cure is the cost to fix it, so we've got to be able to establish what that is. Are always a form of reliance damages. That's not true at all. They're simply a measure of trying to fix the potential breach. C is in fact the correct answer. May not be available if the cost of cure is much greater than the loss of value. This is the economic waste argument that we see in damages. And so you've got to recognize that as well. And then D, are always available if the defendant deliberately breached a contract. It doesn't necessarily matter whether the breach is deliberate or otherwise as to whether the cost of cure would potentially be available. Concept of remoteness, question 5. And again, I think some of these are worded just simply incorrectly if you attack them on the basis of trying to figure out what they said. But that's why it takes a little bit of slowing it down and reading it more than a few times. And I thought a lot of these questions, I personally had to read more than a few times so that I felt comfortable with what they were trying to say, because I think a lot of it was they were deliberately trying to either confuse it or write the questions in a way such that they were stating, in fact, the opposite of the rule of law. For instance, B is based on information that the plaintiff possesses at the time of trial. It's not trial that would be important with respect to the remoteness on damage issue. It's the time of the entry of the agreement and the like. So B is just, it's the opposite. It's not trial that's important, it's the time they entered into the agreement. D determines whether or not the defendant's breach in fact caused the plaintiff to suffer a loss. That's really closer to a causation argument than remoteness. It's sort of it's related, I would say, but it's not the issue. So what do we got? We got C and A. A prevents the plaintiff from recovering compensation for losses that the defendant should have known were a possible result of the breach of contract. It's the opposite of that, right? I mean, that's the problem again. They've convoluted the rule of law. So I think the right answer is, in equity always tries to look at what would be a fair result. That's equity is always based on fairness, so the right answer, and I think that this is reasonable, the right answer is C. In equity, you're always trying to do what's fair and just. Question 6 comes off your old SAT exams so that you can figure out what the appropriate math answer is, even though you hate math and that's why you're in law school. What do you like? 2 trains.
C. I like C.
You like C. C, in fact, I think is in fact the correct answer. I've got a question on it though, but C, in fact, is the right answer because again, you know, the plaintiff has an obligation to try and mitigate their damages. And this really just simply requires you to sit down and try and look at what was going on. And to me, it really is sort of a mathematical approach. She was going to buy something for 20, flip it for 30. Her damage should be 10, realistically. And then you've got to look at and figure out which one gets us closest to that. And if you look at some of the answers, they don't get us anywhere near that. A court would order Perry to pay $30,000 to Georgina. Well, then she gets an incredible windfall because she never purchased the shares to begin with and never paid Perry his 20. So that can't be. That just simply can't be the law. A court, A, if the shares are really worth $25,000, which God knows where that figure comes from, a court would probably order Georgina to pay $5,000 to Nick. Perry refused. Well, theoretically that could be an answer, but I don't know where the $20,000 figure comes from. Other than that might be Nick's measure of damages in some way. But again, theoretically that's a possible answer. B, a court could order Perry to pay $20,000 to Georgina if he knew or should have known that a breach of contract might cause her to lose the ability to perform a resale. Well, it wouldn't be 20, it'd be 10. And C is then, if we go down to it. Here's my question with C that you guys said. Georgina would be denied recovery if she could have reasonably mitigated her loss by purchasing shares from someone other than Perry between March 1st and March 8th for $20,000 or less. Maybe it's the denied recovery. Okay, here's my question. Why does it have to be 20? As long as it's 29,000 or less, doesn't she have an obligation to try and cure and cover? All right, if she can purchase it for 29, so that she then buys it for 29, sells it to Nick for 30, then her loss is 9,000. Right? She's got an obligation to cover, or to try and cure and cover here. So that's why the only thing I'm wondering about is why the number has to be 20 as opposed to even 29. And that may be just an argument, but she still wouldn't be, and maybe that's the way it's worded. If it was 29, the cost, she still wouldn't be denied recovery. Her recovery would just be less. But if she can cover for 20 or less, then she's got to do that. And if she fails to do that, then in fact she's denied recovery. So I think your answer is right. I was wondering what you thought of that. Right? Go ahead.
Wouldn't it be because it's just asking if the statement's true?
Right.
So like, that's true, and if it was 29,000, it would be true too?
Well, but if it's, see, I'm wondering, the more I think of it, I'm not sure if it's 29, it's true. She's not going to be denied recovery if it's 29, because she can still recover against him, but it's going to be less.
Right.
But if she can cover for less than or the same of what she would have bought from him, she's got no damage from him.
Right.
And that's why I think the statement's true. I think I was over putting something into it. She's got to cover if it goes to 29. That's not what the question called for. It says, you said, which statement is true, which isn't.
You were doing a Karen.
Yes, I was. Which of the following statements is true? 7. And again, this requires you to think about reliance and expectation. And I think there's a tendency to confuse those. But I don't know why, but I do see that from time to time on exams. And I just see that as the expectation is what I expected to receive as a result of the deal, assuming that I was going to make a profit. And if you weren't going to make a profit, you shouldn't be pleading expectation damages. You should be pleading reliance damages. In essence, this is what I expended in reliance on the promises we mutually made under the contract. Therefore, since I relied on the contract and have lost money as a result of it, I'm looking for reliance damages instead because that's what I've lost. And so I think you've just got to think about it. The expectation is the expectancy, and it's forward-looking, and reliance, by the time we look at that, really is looks in the rearview mirror as to what you've lost, what you've expended as a result of entering into this contract. And E, restitution can be used to avoid the consequences of a bad bargain, right? If I've spent more than the profit I expected to make, well, then I should be pleading restitution damages. If, on the other hand, I've spent virtually nothing but expected to make a windfall, then I should be looking at expectation damages. And that's what, and again, I think that Pier 4 case illustrates that better than virtually anything. And so A, expectation damages can be used to avoid the consequences of a bad bargain. Absolutely not. That's reliance damages, that's not expectation. B, the purpose of reliance damages is to indicate symbolically that the defendant breached the contract. Symbolically, no it's not. It's to put that person back in the same position they would have been had the contract never been entered into. And that means someone's going to pay damages here. C, if the defendant deliberately breached the contract, the plaintiff is entitled to both expectation damages and reliance damages. Again, you know that's not true. We know that clearly is the Pier 4 case, and you're going to have to, at the end of the day, you've got to pick one or the other, because otherwise it's a windfall. And D is again a misstatement of the law. Reliance damages are not available at all if the plaintiff entered into a bad bargain. Yes, they are. That's when you actually tend to look at that. 8. Oh yeah, what did I say? I didn't give you that. E is the right answer to 7. 8, what do you like? Go on. B as in boy is in fact the right answer. It may illustrate the concept of penalty, and if it is, it won't be enforceable. It's not punitive damages. The other argument, obviously, at the other end of the equation is it could be liquidated damages.
That's what I was looking
Yeah,
for, and that's why it picked E.
But it's not here.
I know, that's why it
None
picked
of the
What?
above.
That's why it
E,
picked
none of
E.
the above.
Oh, so you picked none of the above?
Yeah.
Well, tell me why B is wrong then. And I don't disagree with you.
I don't think it's a penalty. I think it's
How do you know?
your
This was a $10 million contract. Oh no, 7. We got to look at the facts.
No,
We
you're
don't know.
right.
I know, but it says paragraph 7. How do you know how much it was, the performance was? Suppose it was a $10 million contract, 25,000 penalty?
it would not achieve.
But it's
Suppose
not-
it was a $50,000 contract, 25,000 a penalty? Could be closer. What's the matter?
No, I just feel like that, like, the answer is liquidated damages, so I just.
Oh, but it's one or the other probably, right? It's either liquidated damages and that's okay, or it's a penalty and that's not. And liquidated's not here, penalty is.
So liquidated damages is synonymous with penalty?
No. No.
So then,
What's the difference?
so then what's,
They're
so
opposites.
in this
They're
instance,
completely- they're
what's the
synonyms.
difference?
Antonyms, huh?
Then what's the difference here?
Which is money.
Okay, just quickly, right? A contract claim, I did a real estate agreement for my brother this week. There's a liquidated damage clause in there. If the buyer fails to fulfill his promises under the agreement, the deposit is forfeited, and that's forfeited as liquidated damages because the damages will be speculative and hard to determine otherwise. That's what it says, right? That's what you have to stick in. That's a liquidated damages clause. If it bears a reasonable relationship potentially to the damages, or if the damages can't be readily ascertained, that clause will likely be enforced. If, on the other hand, the clause said it's a $100,000 deposit, and the $100,000 is a liquidated damages clause, but the house dealers say $300,000. Actually, you can say $500,000. I think that's a big penalty. If it's $500 and the penalty is $100, you're not likely to see that reduction. Penalty clause is unenforceable because it doesn't bear any reasonable relationship to the actual potential damages involved. And so penalty clause is unenforceable for those reasons, but a reasonable, well-constructed liquidated damage clause is enforceable. So you with me? What's the matter, Ray?
Yeah, but.
I still can't put the two in two different boxes in my head. Because again, when I looked at this fact pattern and I looked at the way it was worded, immediately this was screaming out liquidated damages, and I struck penalty because I kind of figured it doesn't really fit. It's not, because liquidated damages are not a penalty.
Well, but if the amount are disproportionate to actual damages, it's penalty, right?
So we're looking at
That's a definition of the penalty clause, right? And if, on the other hand, they're reasonable, they're liquidated, and that's okay.
So you're basically looking at whether it's disproportionate, and if it is, it's penalty, and if it's not, it's liquidated.
Yes,
Okay, gotcha.
that's,
And punitive is much more than that, as important.
well, punitive and penalty, I mean, we tend to look at
That's why I
them,
messed up.
punitive damages, are really have a different context to what than contract damages generally.
And they're rarely rewarded anyway.
They are,
That's not like.
but this is the contract remedy they're looking at here.
But can't punitive damages be considered as a penalty in some cases?
I could see where a penalty clause could be so large that someone, or even the judge, might use language that it's merely punitive and therefore doesn't satisfy the requirements of a liquidated damage clause.
That's why they don't use this question anymore, I'm sure.
Well, this is not even a bar exam question at all.
Oh,
This
really?
is-
Oh.
Yeah, this is some of the books and stuff. I wouldn't worry.
Because I got confused between those two.
These are not great questions. They're good questions to discuss and debate. I actually don't have a problem with this one because you were looking for the antonym to penalty, right? Well, it's not there, and so read the.
So none of the above.
No. Are you saying that? Look at the language in 7. Paragraph 7 of the parties' contract may illustrate the concept of the penalty.
Right, but if it's not gonna be enforceable,
That's what makes it a penalty. No.
then it's not.
Penalty's a better answer.
What?
Penalty is just the better answer.
Yeah. Well,
So just from my.
okay, listen, let's try it just quickly. When isn't a liquidated damage clause enforced?
When is?
When is it not? Huh?
When it's unreasonable.
Is that what the language is?
No, it's like way more detailed than that.
No, but it's not, right? It's not way more detailed than that. When does a liquidated damage clause cross over the line so that the court won't enforce it?
When it's likely to exceed the actual damages, or?
When it's a penalty, right? Don't you still use that language in contracts? No, right? You still use that language in contracts, right? If it's a penalty clause, it's not enforceable. If it's a liquidated damage clause, it is, right? What do you say? If Professor Sullivan said it, then we're done. So that's all. I know you were looking for one, but I think it may be considered a penalty. Maybe it's not. May be considered a liquidated damage clause. It could be either or. We don't have the rest of the parts of the agreement here, so we really don't know what the provision is, how many computers, and what the cost was. 9, Perry sues Jane for specific performance. Which one do you like here? B. We have closer to agreement on this. B is in fact correct. At least they say it's correct. Again, we could debate this. You could debate the last one as well. This is the problem when they have none of the above, because you clearly can figure out scenarios where you say, well, no, I don't see that's right either. But you know that we had this problem when we talked about it, both in the context of personal services contracts in general, and even the surrogacy contracts that we're worried about. Which, by the way, I've got an interesting case. I'm going to bring you on that one as well. Just an article. A woman who had her children with donated eggs or purchased eggs. I don't know which it was. Huh?
Is this the Israel thing?
Yes.
Yeah, we talked about it in another class too.
In con law or
In
whatever.
Rudnick.
Yeah, she was telling me at lunch. She said, "No, Connor, you have the facts wrong. You have to have the facts wrong because it's so far behind what the status of the law in most states is." Well, what happens is she has the children in Israel, but she's an American citizen. She gives birth to them, but they were donated eggs, and then she goes to get their passports, and the embassy says, no, then they don't constitute your children because you used a fertility clinic for the eggs. The children, even though you were the procreative parent, you physically even gave birth to them, they can never be American citizens because the way we look at it, the way the U.S. State Department looks at it, and they have a little book to check, it doesn't necessarily matter who mom and dad were that gave birth to the idea, it's who donates the sperm and the eggs by their criteria.
Only American eggs.
Brown eggs. So I'll get you the article, but I really thought that because it's just so foreign to the status of what the law is in most states, and even the article goes on to say that as well. It's really shockingly sad that the State Department is so far behind both technology and the law in that regard. But obviously it gives rise to issues that somehow you ought to be talking to your clients about as well. As don't go out of the, if you've got people you're consulting with on this, do not go out of the country if you're close.
Is that case still pending, or?
I asked her that as well, and the article seems to indicate the woman has given up, which I think that's a shame. I'll get you the article and you can take a look at it. It's well, it said, for whatever reason, it said that won't work now either.
What if they had someone else adopt?
Because when you're, no, you can't, well, yeah, but you can have people adopt your children.
Or your husband?
No, or you have a family member adopt them.
I know, but still then,
They're illegal.
right? And then, by the way, then you've got other problems because then the adoption was for fraudulent purposes. Okay,
Yeah,
but
you're gonna love
I'll get you the article. It's a very interesting and disturbing article on a number of different standpoints. But this is another example where technology is way ahead. The law is even further, at least a tad behind. But the rules that they're enforcing are ridiculously out of date. So 9, we got B. 10. Rosa says sued Lothrop for unjust enrichment. Which of the following statements is true? Rosa will receive restitution if her claim is successful. 11, a power plant spews out large amounts of pollution on neighboring houses and farms. You read the question. This injunction is best described as, I thought this was just interesting for you to start to think about the different forms of injunction. We never put names on them, and I'm not big on you having to know exactly what the theory behind what we're doing is, all of which is possible. We're going to see again some of these issues next week as well. But this would be considered prophylactic. It doesn't really restore, it doesn't prevent the problem, and it doesn't prohibit them from doing anything. It's simply a stopgap measure. 12, Again, another damage question. He gets restitution for the amount of the fire extinguisher. If he did this commercially, might be able to get the value of his services, but he donated those services, so he's out of luck on that. 13, this is in fact a punitive damage question. What was 12? 12 was D. He gets fire extinguisher, not the value of his time. You're never going to get an injunction under A to get back.
Wasn't it B?
What did I say? B.
D.
You said D.
Oh, I'm sorry. B is important.
Even though she didn't want him, she didn't ask him to come, and he was just a neighbor.
Still,
You get, I believe you.
I've expended the fire extinguisher. I mean, I'm entitled to get my fire extinguisher back, aren't I?
But I didn't want you to put out the fire.
Well, you still got something of value, whether you realize it's of value or not. 13, this is the whole punitive damage argument. We've looked at it in CITPRO. You probably looked at it in other classes. The least likely to be effective is A. The other arguments, we see that in various cases where the other arguments have some legs. Constructive trust and resulting trust we're going to look at before we're done. They are also equitable measures where the court imposes on property, again, usually real property, but here it would be the Harley, where you're trying to trace, in essence, the proceeds of what was lost here. And if it's a constructive trust, I get the profit. I don't just get what I lost initially. So it would be E, a constructive trust on the 86 Harley. That way I get the profit as well. We'll see what a constructive trust and resulting trust are in the week that follows next. Which of the following equitable defenses are most likely to be applied in an action of law under 15? And again, I thought this was important to think about. It's clearly B, unconscionability under the UCC. That's in all contracts now. A is as well, though, by the way.
That's why.
Estoppel is likely a defense you'd be able to use in an action of law. Laches and unclean hands, though, those are really limited to equitable actions, injunctions, declaratory judgments, specific performance. And the reason we have some equitable defenses and some defenses at law is up until the 1970s, even Massachusetts had two court systems, in essence, within the same court, but we had actions at law and actions at equity. And so some of these defenses were only available in either law actions or equity actions. Laches and unclean hand. Laches, a delay which causes prejudice to the other side, and unclean hand. Someone's coming to court with dirty hands, having done God knows what. And there's an adage that goes with it, one who seeks equity must do equity. And so if you come in with unclean hands, the court isn't going to do anything for you, at least that's the theory, in an equitable action. So laches and unclean hands still, even today, those defenses are limited to equitable type actions, injunctions, declaratory relief, specific performance, actions that historically sounded in equity. Unconscionability and estoppel really have now moved over to both equitable and legal actions. 16 is an evidence of indirect contempt, which the court can sanction, but they cannot do it in this fashion, and so it's invalid with respect to what they did here. 17 asks you to value damages. So 16 is D, it's an indirect contempt. When we pursue these claims for future damages, there's always a couple of arguments. We see them made from time to time where partly the question turns on taxability of some of these items. And again, I would recommend, to the extent you can, take a tax course before you leave here. But also the notion that if we're really going forward in the future, at some point, to give you all of that today doesn't reflect your actual losses. So how do we calculate what your actual loss is when you put in the damages that at today's rates, they estimate that the care will cost $10,000 per year. The right statement there is that you will give them 10,000 per year for the duration of Hal's life, and you can adjust that for inflation, but then you have to reduce it to what the present value of that cash is. So the right answer is C. Because the rate is 10,000, but that rate will increase over time, so that you can increase it by the cost of inflation, but then you've got to drop it all back by reducing it to the present value of that cash. Do you understand that? If you're 20 years old, your life expectancy is at least another 50 years, we'll say. Okay, but your future cost of medical care for those 50 years is 10,000 per year. 10,000 per year times 50 years. How many zeros? What is it? 5 million? It's got to be probably even more. No, I don't know what it is, but if
We need a calculator.
50 years, 10,000, 1, 2, 3, 4 zeros. It's $500,000. Okay, that's the lump sum you would get. But I can't give you 500,000 because that's really not what you. If I give you 500,000 today in year one, and you invest that, you're going to have a lot more than the 500,000 needed. So if it's $10,000 per year for the next 50 years, we got to say 10,000 a year plus the cost of inflation. And again, I don't know what that is. We'll say it's 600,000. Could be more. But we got to reduce that to the present value of that cash today, because I'm going to give you all that at the end of this trial, in essence. And the likelihood is that in order to get 600,000 paid out over 50 years, I don't have to give you much more than 4, maybe even less today, to be able to have that actuarially figure out to 600. So that's what we say is adjusted for inflation and then reduced to the present value of that cash. How much would it take today to put in the bank or to give to a life insurance company or whoever else to say, I want to get 10,000 a year for the next 50 years, and that's going to cost a lot less than the whole payout over that time period. That's why you see those things on daytime TV. Is what was it? JR something.
Jim Sokoloff.
What? No, not even Sokoloff. The people that will
Wentworth.
J.D. Wentworth. They'll buy your annuities for present cash value. That's the type of thing they do. Yep.
If it's the same thing they do with the megabucks.
Yeah, exactly.
If you take cash. But wasn't there a case where they said that they weren't going to do maybe it was something else, but I was thinking it was the
Nope.
inflation, because the clerk does it?
Oh, the clerk doesn't do the inflation at all. What the argument is, at least in part, is if we don't do this adjusted for inflation, reduced to present value, that those two things will offset each other. Just give me the value of what those damages are. And by the way, the whole notion of adjusted for inflation or reduced to present value, the defendant's got to make an argument on that. You got to make an argument that the damages I put in are too speculative or a windfall, because as the plaintiff, I'm not going to readily admit that they need to be cut to present value, because why should I? That just hurts me. And so that's another way we have to start to think about defending the cases as well. Okay, I've got it because I got to get this done to the extent we can. 18. And we could argue about 18, I think, because we've argued about it in other cases. Is it C, 3,000, which is pretty clear, or D, which would give them the inspection plus the profit? Yeah, they say D, and I think that's right. Although we've had arguments before that well, you would have been out the 500 anyway. So that's your sort of your sunk cost no matter what. You're not out that. You're out $3,000 because in essence you would have made $2,500, right? Because your cost would have been 100,000 plus 500. Your profit's 103. You're out 2,500.
500 for
Wait a minute.
inspection.
No, but I'm going to be out another 500 when I go to inspect the next house.
Yeah, so
So then ultimately it's $3,000. It's all you're out. 3,500 is a little bit of a windfall. At least that's the other argument.
No, where's the other one?
No.
It's the other one, because he should get.
How much would it cost you to have bought this house?
We'll say
100.
they-
100.
I'd
So
say
you
the
weren't going to do an
300
inspection now?
Isn't the 500 Reliance reliance damage where he spent the 500 to inspect the house in reliance that she had good title to sell
But
it?
you don't get them both,
You don't get them both, that's right. You can either have your expectation or reliance. You don't get them both, right? We did a question on this
Well,
already.
then B and C would be wrong then.
Yes, that would be correct.
Well-
But here's the other problem, okay, and there's the other problem though, is if we just look at expectation, then aren't your damages only 2,500? Your cost is 100,000 plus $500,
Right.
and you would have got something worth $103,000. The difference there is 2,500, and none of these say that at all.
Right.
So we either go with D, but we just by our own math, if we're going that calculation, C's not right either. They say the right answer is D. But again, this is
So
one
what
of
kind of
these.
damage is the 500, would you guess they're saying the 500?
They're not.
Well, if they're.
Why are you getting the
then
5
it can't
and the
be
3?
reliance damages, there has to be something.
But when you're doing real estate, you wouldn't be getting it anyway. So like, if, for example, it wasn't a breach on her part, or say you walked away, it's like that, you don't get to get your money back for the inspection, no matter who breached it.
Yeah, but why not?
They're doing.
I know, but in the straight measure of damages, why not though?
Because I think it's like you said, it's some concept, you took that upon yourself, you didn't have to get the inspection at that
Well,
point.
and that's true too. It's not, if you weren't required to do that, you chose to do that.
Right.
19. Too speculative. So listen, they say the right answer is D. Who's the hell? Who are they? I don't know.
Who are they?
Who's they? Listen,
Wait, what's
you're not
the
going to have a
other-
question like this. You're just going to be prepared to make the various arguments. I've said we don't have.
I think it's talking about the thing.
They say the answer is D.
Oh.
I'm giving you the alternatives because I'm not crazy about D myself either, okay? You're not going to have a question like this. You should be able to debate it and argue it because I don't think that's a clean question about what the damages would actually be in that case. 19, I am comfortable with this. And her damages are here are too speculative, okay? So C. And then 20, I'm very comfortable with this as well. The answer is C. Right? An evidentiary hearing is provided on a request for injunctive relief if there is a sharp factual dispute where the credibility of witnesses may be an issue. Credibility is for the fact finder to determine, and we've just got to take a quick look at the last case for this class, or for this section. And the reason I pulled it down is because I know you've seen from time to time some of these findings of fact and conclusions of law, but this case, this decision, really simply lays out straight findings of fact and conclusions of law, and it's not written, in essence, as one of the typical decisions you've read, but this is in fact what findings of fact and conclusions of law look like as the court would go through it and formulate its decision. And I thought it was an interesting case because it's down in Boston. We see a lot of these issues about, and they become encroachments and nuisances and trespasses and everything else, whether they're fire escapes or bow windows or God knows what. And so it's not uncommon that we have these problems. And it talks about proving issues of trespass and the like. And it also talks a little bit about some property issues about prescriptive easements and the like. But I thought it was really as important for you to look and see how findings of fact and conclusions of law are set up. And now this is the judge's decision, but if you were to propose it, file proposed findings of fact and conclusions of law under Rule 52, they wouldn't look that much different than what you're seeing in this case. And anytime we have a non-jury case, there has to be findings of fact and conclusions of law entered. And here they're entering them on the request for declaratory judgment. But if you look at the relief section as well, it's not just going to be that the declaration will issue. The court is also requiring them to take steps to remediate the problem and to pay the costs and attorney's fees for having done the problem to begin with. And that's not unusual either if you look at the last part of the decision, that sometimes after the case has been, the judgment is entered, the court determines attorney's fees are due, there now needs to be another phase to that hearing process where the parties are going to have to submit, or the one party is going to submit their request for attorney's fees, their application for it, and then there may be further hearings, there will likely be further hearings on the resolution of that as well, because the other side's not just simply going to pay all the fees that one side wants here. And so sometimes those attorney's fees claims that happen also become another piece of litigation that will take some time to resolve. And here, what the court does, again, not that unusual, retains jurisdiction to assess the attorney's fees that have to be filed. The process then would be, you would file affidavits, you would file your request for payment with respect to your time that you've spent on the case, with likely contemporaneous time records that you should have kept if you now want to seek payment from the court at this point, since they've awarded it. And it's another reason why we have to keep contemporaneous records of our time, either when there are potential statutory awards of attorney's fees, or the fact is that you're seeking attorney's fees because of what the defendant did. It's important to keep them on a daily basis so that later on that you can then recover them, because if they're done after the fact, they're just simply not nearly as reliable. And sometimes you don't always do that if you've got a case on a contingency basis. But if you've got the case on a contingency basis and there's a possibility of a statutory award of attorney's fees, you still got to keep track of your time, because you will be, hopefully if successful, you'll be asking the court to make an award of attorney's fees. So I thought that was an interesting case on a declaratory judgment. And we will talk next time.